Dear colleagues, let us begin our session devoted to intellectual property. There are two of us here on the podium today. And first of all, I would like to give the floor to Elena Pavlova, who represents the Center of Private Law, and she is one of the participants of the working group on intellectual property that prepared amendments to Part 4 of the Civil Code. So she is in the best position to present those amendments to you, and then I will, if I can, I will express my opinion, and then we'll be ready to respond to your questions or comments. We will have a free and open discussion. I hope we will spend an interesting an hour and a half. Can you hear me? Yes. Yes. Good afternoon, dear colleagues. We will talk today about those amendments that are planned to be included in Part 4 of the Civil Code. Of course, I would like to first say what the draft law is at the current stage. We had a separate working group on Part 4 of the Civil Code, first of all, based on the Council of Codification. They created several working groups. Each one of them worked on a separate section of the Civil Code. And the task of my group was to, in accordance with the concept of the modernization of the Civil Code, was to introduce separate changes, as it was referred to then, into Part 4 of the Civil Code. So those were supposed to be clarifications and supplements, because Part 4 of the Civil Code was enacted on the 1st of January 2008. Part 1 of the Civil Code was the main reason, of course, for amending the Civil Code, and we could there justify the need for amendments because quite a lot of time has elapsed by the fact that the code was developed when we only started to develop the mature stage of business turnover. And now, well, in 2008 everything was already in existence, but in reality problems related to intellectual property and the fact that Part 4, at the time of its coming into force, it was clear that this part of the Civil Code is not quite in line with the modern realities of the development of the society as a whole. At that time, we had to codify our legislation. We needed to bring everything into a single law, to integrate it into the Civil Code, and we could not solve all the problems that surfaced at that time. And in 2008 it was clearly felt that draft Part 4 of the Civil Code lacks certain elements. We wanted to include those elements into the code in the course of this modernization work. What kind of problems did we have to overcome? Those were problems related to new phenomena related to the science and technological progress, that is, informatization of the society, electronic documents, electronic means of dissemination and recording of products of intellectual property via the internet and multimedia networks. We also had problems related to the legislation on industrial property, which hasn't been amended for a long time, and Rospatent, the agency responsible for this legislation, at the later stage, when Part 4 was already in the State Duma, submitted their proposals on the necessary changes to the industrial property legislation, but those proposals were so broad and diverse that it was not possible to handle them properly at that advanced stage of the draft Part 4 preparation. We streamlined those documents and proposals, and they were ripe for inclusion into the code. And we also understood quite clearly that since 2008 certain time has elapsed, certain rulings by the Supreme Court of Russia and Supreme Court of Arbitration were adopted, explaining the provisions of Part 4 of Civil Code. We have accumulated some case law. We responded to various questions of practicing lawyers related to lack of understanding and different ways to interpret different norms and provisions. It became clear by then that certain regulations need to be clarified. So those were the three main points that we were guided by in our work. With regard to the content of those changes, when we brought them together and when we looked at it at our working group meeting, it turned out those amendments turned out to be not separate instances. Actually, we amended 50% of the 50% of the provisions of Part 4 of the Civil Code, or to say it more correctly, Section 7 of the Civil Code. So these regulations, these provisions are included actually in Section 7 of the Civil Code, and this is part of the whole body of civil legislation. The majority of amendments were to be included in chapters 72, 73 and 76, dealing with industrial property rights, and those amendments are quite profound because they deal with such fundamental issues as, for example, in the patent law, where we change the approach to the registration of the so-called useful models. Industrial prototypes are now treated differently in a more, so to speak, European way. We start to define this industrial prototype in accordance with the existing international legislation. It is a result of design activities, and this is closer to real life. It is closer to means of individualization as the trademark. Sometimes it is mixed with the trademark, and we have introduced certain provisions as to how to differentiate between means of individualization and trademarks and industrial prototypes. We are there resolving issues related to certain needs to upgrade the expertise, the expert evaluation, both in the with regard to inventions, useful models and trademarks. This is quite well grounded because those amendments were necessary for a long time. Another important point that I would like to highlight in this respect is the relations between the results of intellectual activities and means of individualization. They are subject to state registration. and this also refers to contracts concluded in this area. With regard to contracts, we've always received a lot of criticisms about the procrastination of the procedure of registration. Rospatent, it takes Rospatent to register these objects. It takes them a long time. And it is not only about the time frame, but also commercial secrets are disclosed, because you have to submit the texts of contracts for registration. Now there are plans to significantly change this system in such a way that we don't register contracts anymore, we register rights. That's the overall approach of the Civil Code. It is also a characteristic of Part 1 of the new Civil Code, or draft Civil Code. And in connection with this, you don't need to submit the text of the document, you need to submit certain data about the contract. And you register by way of submitting an application. You just have to submit a certain amount of information, and that's it. The contract is thereby registered. No bylaws, no secondary legislation will be needed to provide additional guidance. So this simplifies the overall procedure, makes it not as lengthy as it used to be before, and those parties to the contract are now able to maintain secrecy around certain elements of the transactions. Article 72 about patent relations. There we are proposing to introduce another article which introduces such sanction as compensation. It already exists with regard to copyright and similar rights. We are proposing to introduce it with regard to inventions, useful models and industrial prototypes. This will help to protect the right, the title. This sanction is used against in place of compensation for damages, and if the right holder doesn't have to prove the size of the losses, the amount of the loss, he must also only prove the fact of violation upon his right and title, because it's always very difficult to estimate the amount of losses sustained. Amendments in the field of industrial property rights are not long in terms of text, but they are quite serious in terms of consequences.
As for Internet-related issues, as you might understand, this is a sphere for Article 69 and 79 on related 71 on related rights, and here we have to address several issues, well, like information intermediaries or internet providers. A special article 1253/1 was introduced that provides for the liability of such information intermediaries. It's no secret that quite often they are not violators of exclusive rights, but users that are acting in their space may be violators, and the rules regarding liability in this sphere are impacted by international treaties and agreements, and the liability is valid for such persons too. However, it contradicts our general rules regarding liability for a guilt, and it requires justification. So we do have court practice, but it is quite diverse. So that's why we are following the international practice and the practice of other countries that have successfully resolved this issue, namely that information intermediaries must be held liable, but on a limited scale. This article spells out that there are two types of information intermediaries: the ones that transfer information and store information with the help of their resources. So they are liable for the guilt in accordance with civil rules, and this is also a sort of softer measure for them, because you know that liability is plausible without a guilt. Most of information intermediaries are businessmen. And the second part of this article defines this situation, and if the terms are met, then no liability comes in place. So hence, general rules that are existent in many countries are applicable. So the person that transfers information must not impact the content of information, must not impact the choice of persons this information is transferred to. The person that stores information, if they know about violations of intellectual property rights, then they must not transfer such information and take measures to prevent possible actions. However, within the framework of civil code, it is not possible to describe the mechanism of the interaction of the right owner and the information intermediary. So there must be a certain regulation that would spell out such issues. Another thing that we cannot impact the speeding up of such a document adoption. So there is a reference to the legislation. So, taking into account all the comments that we have received, we would like to change the wording and write down what necessary and adequate measures are, and they should be regulated by law, because if we are guided by the definition exclusively, then a court may decide what adequate and what sufficient and necessary measures are that may come into force right after the adoption of the civil code amended. Another problem that surfaces, but with regard to the internet, all the cases of free usage without the agreement of the right owner and without paying royalties, or with the consent of the right holder but without paying royalties, must be enumerated in the civil code, and there can be broader interpretation. You know, we have lived for quite a long time, allowing many people to violate the legislation, in fact, because the cases of free usage that were previously contained in the law on copyright, and now they are in Chapter 70 of the Civil Code, does not include cases related to the internet use. When we developed Part 4, we were asked by the international community not to touch upon the provisions because WTO negotiations were taking place. It was quite painstaking, and we were scared of intruding in the area. We are now on good terms with WTO, and we now can amend our legislation. Moreover, European countries did it long ago. Article 75 provides for the digitization of analog copies of books from libraries, and it is done all over the world. The only thing that cannot be done with books in other countries is to feed them into the internet. So our wording is similar. Digital copies of books in libraries can be made so that readers can read them in the premises of libraries, but it is not allowed to upload these copies in the internet. Well, I think that you need to do it in proper time and allow this option, but remuneration should be paid for, and we need to understand how we are going to do it, bearing in mind the collective management system that is not ideal. So we need to sort out the situation with this management system and then introduce a measure. A third problem is signing agreements in internet. We have a provision on wrapping, on shell licenses. So if you buy a certain product on a CD-ROM, the civil code contained nothing if the same program software is downloaded from the internet. Now, Article 1286, in its current wording, can be applicable for contracts signed in internet. So it broadens the notion of the simplified license agreement with the user. So in Article 1235 on licensing agreement, there is an amendment. It allows to sign a licensing agreement without any compensation between commercial organizations. So as for alienation, it is written down that it is not allowed because it looks like a contract of a gift. As for exclusive license, here there is no handing over of the title. However, because it is about the monopoly rights, then it was allowed that exclusive license is not allowed and non-exclusive license is allowed. This is exactly what you usually have via internet. But another thing that gives rise to a lot of debate is unilateral disposal by the right owner of the right. So Article 9 of the Civil Code and Article 29 allow the right holder to dispose of the exclusive right as any civil right at their own discretion and even abandon this right. Another thing that put together these two articles are not sufficient to make sure that people are aware of it. Moreover, questions may arise amongst financial bodies and taxation bodies, so it was desirable to identify a specific pathway for people who would like to enjoy such actions. Thus, item 6 of Article 1233 appeared, which provides for a unilateral disposal of the right when a person can publicly announce that within certain limits they allow to use their work or another product of their intellectual activity to anyone. But certain terms are included that can be resorted to. Initially, this wording was very broad, but when the discussion took place and many right holders organizations opposed this document, it was decided that these things will be carried out at the website of Rospatent. It also brought about a lot of opposition, and there is an intermediary article that provides for a larger number of publication locations, like the website of the right holder and also a copy of the right holder's work. In the internet there might be an information supplemented to the website, for example. And upon the request of the President of the Russian Federation, we were to prepare our legislation to be able to admit open licenses that exist throughout the world, and they are interpreted as bilateral contracts, bilateral transactions. And Article 6 of Item 6 of Article 1233 is not appropriate, so there are no amendments introduced yet, but we do have certain ideas how we can document such licenses. The thing is that many countries have not amended their legislation to include such options, which is explained by the developed system of courts interpretation. But in our legal system, it is not a typical arrangement, so that's why it was decided that certain amendments must be introduced on the issue. Unfortunately, I cannot dwell on it now. Maybe Igor will talk about it. There are different arguments here, and there is an attempt to address the issue. I think that I have provided you with a lot of information. I may have talked even longer. So let me be a co-presenter, as I'm representing the Skolkovo Foundation, that is to stimulate innovations. So I would like to evaluate the amendments proposed in terms of their potential to stimulate innovation and to comment on them. Since Yelena started with comments on industrial property, though they are given after copyright in our code, but I would like to say that, first of all, we are talking about patent law. A lot of amendments are introduced. The only thing that I would like to draw attention to is that this is an initiative of Rospatent. It has both advantages and disadvantages, and the thing is that apart from Rospatent, the expert community did not participate in formulating the amendments. Well, I'm in no way reproaching the developers. The thing is that the experts' environment hasn't been formed yet. there have not been concerted efforts yet because they are of no interest for the public at large and for the business community, because a patent is not a source of earning money yet. We have not understood it yet, while this instrument is actively resorted to abroad. So one of the tasks for our economy is to change the situation dramatically. Huge changes are made with regard to useful models, and actually there is an examination on the substance apart from a formal examination. The reasoning behind this examination is clear. If the examination is only a formal endeavor, then obviously you can argue a patent at any time. So we actually have come across a lot of claims because applicants obtained patents easily, thus they misled the market. On the other hand, a utility model will lose its advantage to a larger extent because the period for issuing a patent will be more lengthy, and it is also necessary to understand how we should issue patent and what for. The trend in the world and in the USA is to issue as many patents as possible. Is it bad or good? Well, it's no coincidence that a lot of patent wars have emerged recently, and the density of patents is increasing. That actually impedes the quality of examination, because just imagine how many documents must be studied to reissue a patent. Also, it impedes the analysis of inventors, because other people may capitalize on their patents and enter the market. So actually, the problem faced globally is whether we should issue as many patents as now. But for Russia, this is not a topical issue, especially for the domestic market. In my opinion, we should stimulate the patent institute because we are lagging behind. Other changes, the ones offered by Ross-Patent, are considerable, but they are procedural, pertaining to the procedure of examination. So another conceptual issue arises here with regard to the necessity or lack thereof of appearing of Part 4 on intellectual property rights.
So the question is whether those procedures should be spelled out in great detail at the level of the code or at the level of secondary legislation, and so on and so forth. A certain balance has been achieved here, I think, but we need to further elaborate in this area. If you take Part 4, in terms of volume, articles about the procedures within Ross-Patent take up most of the space. We should stop somehow at some point, because otherwise the civil code will grow and grow and grow in volume. But in general, patent law doesn't provoke a lot of criticisms, because for us these issues are not so significant economically for us, unfortunately. If we take copyright, here the situation is totally different. There are heated arguments about the interests of right holders, users, the internet community. The interests of all those groups are mutually exclusive. Therefore, the debates are very hot. I would like to point out certain things that I somehow singled out while I was looking through the amendments to Part 4. Now we're talking about the internet because this is exactly what the authors of amendments were working in the last several weeks. Elena didn't say that, but still I think it is important to mention that the results of intellectual property and the rights thereof, they do not for them such notions of the INREM law as operative management do not apply. Here we are talking mainly about the rights for the results of intellectual activities that belong to state organizations, scientific, educational institutions, because it is there that a lot of intellectual products are produced. We are not going to evaluate here their quality and potential monetary value. It will probably grow with years, and this may become a significant source of income for universities, say. To manage those products, people should enjoy appropriate freedom in managing them. We cannot say that they have received this freedom. For what reason? When we're talking about property, movable or immovable, that are in operative management, of course we need to comply with the requirements of the code, whereby we need to undertake certain approvals process in order to introduce this operative management regime. So the INREM law only covers material things, and results of intellectual activities are not material things. But still, those issues are still on the table. Professor Tolstoy at the plenary said about the state corporations and the property belonging to them. It is neither state property, it is the property of the state corporation, but the status of state corporation as such somehow contains a hint that this is in fact a private entity, but you can't say that it is private property belonging to a state corporation. So those rights for intellectual property, they belong to the university, and it seems to be that this is private property, but the university may be a state university, so there is this collision again. So still there may be questions on the part of various inspectorates as to how effectively this property was disposed of. Why did they sell a license for this or that amount of money and not more or less? Some control must be exercised, and they will exercise this control, because it is not private property, it is in effect state property, because it was created through state funding. Maybe this doesn't deal directly or indirectly with the civil code, but still it is obvious that we need to somehow solve it. And there is also provisions of Law 217, according to which it is possible to contribute intellectual property rights or products into the authorized capital of legal entities. What was correctly pointed out at the plenary, that if it is not allowed, if it is not prohibited, it is allowed. But we continuously write that you can do this, you can do that, you can do another thing, because people are afraid and to do something that is not directly allowed. Now about the internet, we have to agree that, strictly speaking, we don't have logically consistent set of legal provisions that would regulate the internet space. Now what we have is just the first attempt, which is obviously not going to be the last. Those relations are outside the sphere of regulation, and everything that occurs in the internet is the reflection of the real world, and the same norms should apply. This would be an easy way to tackle it, but this is not really so, because physically certain norms cannot be applied in the internet. We, in the international field, often see a trend whereby the G8 countries are trying to apply real world rules to the internet environment, the copyright, for example, rules and principles of fighting piracy. But technologically, the internet is such that it is impossible to effectively apply these rules to the internet. Slowly but gradually, a special body of regulatory norms is created with regard to the internet, and why the battle that is fought today is so fierce. Because, well, some time will pass and the relations that will evolve in the internet will suppress those relations that exist in the real and material world. It wouldn't make sense, I think, to regulate such relations with our day-to-day rules. Speaking about specific changes, I would like to say that what will happen will be the legalization of licenses on the internet. So when you download a program, you just press a button, I accept the license conditions, and this means that you have entered into contractual relations. According to the existing legislation, we cannot say that those agreements are legally valid, because according to our law, those instruments should be on paper, and those electronic licenses couldn't be a substitute for them. At the round table on the internet, a representative of Google took part, and he was kind of surprised and said, you go into the cafe and the Wi-Fi is free, and he is not surprised by that, but he was surprised that before you go online, you don't sign any kind of agreement or license. And I think this is the reason for discussion that we had with Yelena, among other people, about how free licenses should look following the Creative Commons model. Now it is a unilateral transaction whereby the right holder gives the right to use his intellectual product to third parties free. He doesn't enter into any contractual relations with this third party. He just unilaterally grants this opportunity to the third party, and the representatives of the internet community who insist on Creative Commons idea, they do not understand that. Because in the US, everything is somehow underpinned by some sort of a contract, whereby the right holder waives partially or completely some of the rights that he possesses, and the user accepts certain rules established by the right holder on his part. In the US, it is always a contract of some sort. The amendments that were prepared by the Skolkovo Foundation together with the Russian Association of Electronic Media we prepared them for the second hearing. and those are based on what we discussed at the Center for Private Law. So we are proposing to add the institution of open licenses in the form of contract. I hope there will be two parallel models, a unilateral transaction and a contract. We're trying to state that nothing will work without it, and well, life will tell, time will tell. What will be used, what will not be used. Maybe we are mistaken and we don't need two similar institutions. Maybe we need one or neither of those. So time will tell, and practical experience will cross all the T's and dot all the I's. So what happens with the intellectual products created on the order or through an order from the government, and everything that is ordered by the government must be public property. There is an idea like that the rights should not belong to the state. The logic behind is quite simple. If the government invests money and acts as an ordering party, it is done for the benefit of the society by definition, so the government should not earn any revenues. Therefore, the rights should be in the public domain. Here I would like to follow the evolution of this idea, the classical approach whereby the state, the government, and if we're talking about industrial property in the field of R&D or certain government orders regulated by copyright, and usually the usual case is that the contractor does the work and the intellectual property belongs to the one who ordered them. But there is an idea to give the right to those who perform the work. And from the point of view of the general theory of contracts, is quite strange when the outcome of contracted work belongs to the one who did the work, while the other party pays for that. This is kind of a gift. But why should this gift be given to the one who did the work? It should be given to the society as a whole. But this discussion is ongoing. I don't know what it will lead to. Will we come to this revolutionary solution that, for example, whereby movies created at the order and with the funding from the government will be in public domain and no one will receive any royalties from the proceeds? This is under discussion, and this idea exists. Now, the last thing I wanted to say
on information intermediaries, it is true that special rules are introduced with regard to organizations that provide access to the internet content, because otherwise, if we didn't have Yandex, Google and so on that provide for searching information, our life in internet would be quite difficult in terms of finding specific content. But right holders combating illegal content in internet try to find a scapegoat, and one of the scapegoats, in their opinion, is an information intermediary that provides such access. The most conservative position is that prior to providing this access, the information intermediary must make sure that the content he is providing is legal. But since Google has an automated search engine, obviously it eliminates completely this business because they have to analyze manually the information they provide access to. So it is a deadlock, and obviously right holders won't be satisfied with it either, because the speed of access to their content will change too. So the approach of the draft amendments is offered. It was formulated in the USA 10 years ago, as well as in the EU. Right holders, when they see that information intermediaries will provide access to the content, then a certain warning must be issued to an information intermediary so that this content access is closed. Then a debate is unfolding pertaining to the fact that rules are not detailed enough. I think everyone agrees. But another thing, whether it is possible while preparing the modified code to develop all these rules and include them in it. We are guided by the idea that it is not necessary. Probably such details must be given in special regulations. We'll see. Probably some clarifications must be made. For example, with regard to the person who placed the content, they may oppose the statement that, for example, this content is legal, it was not the right holder who appealed to you, and so on and so forth. And then there might be a dispute between the parties, but further detailization is not needed at the current stage. It is not what the civil code is for. I'm not going to abuse your attention. We are ready to answer your questions and listen to your comments. Criticism, praises. Natalia Abramova, the Department of the Civil Law, St. Petersburg State University. I have 3 questions. Number 1. Part 4 is connected to such a thing as a norm of a complex object. Actually, this norm did not give any positive spirit, vice versa. It is very confusing. With regard to a complex object, there is no notion of multimedia and so on. Will these notions be excluded or clarified in the proposed draft? Because instilling legal regulation for notions that are non-existent is quite a task. So shall I ask all the questions at once or one by one? In fact, we are collecting all the comments and criticism on part 4, but on Article 1240 we don't have much objections. The only thing that is against the notion of theatrical and show performance, it is objected to by the RAO. And it is widely applicable now. It is applicable practically to any performance. Only the presumption is changed. What kind of contracts are entered into by the creators of a performance? According to a general rule, the presumption is that it is a non-exclusive license, and the summary is that it is a contract of alienation of the right. It is an optional norm, so any author of a part of a complex object may come to terms that it will be a license agreement. If a playwright is asked to alienate the right of ownership. He may ask, or she may ask, for such money that the theater wouldn't like to enter in such a contract, or a license agreement may be concluded. So we don't see many problems here. As for multimedia objects, we don't see any difficulties at all. If there is no definition, then court practice may sort it out. It seems to me that too often we want to clarify and then explain everything, where actually a court judgment may be awarded. So far, we are not going to do anything about it. Well, single technologies are excluded because Chapter 7 is excluded from Part 4, and the list will include a database and an internet site, because a database is a complex object and a site looks like a database, so it must be easily put into circulation like a single object. The second question is about law enforcement practice. For general jurisdiction court and other courts, somehow judges are very much afraid of applying delict liabilities in case of violating this right. Well, sometimes they think that this is a conditioned character or that's an exception, but there is a practice in the general jurisdiction court and other courts bypassing somehow these cases. So does the draft address this issue? I do understand that, in fact, is a step-by-step instruction that we have instead of a law, but maybe it is necessary for courts. In fact, there is a theoretical position on the issue. It was expressed by Alexander Markovsky in comments to Chapter 4. They say that yes, delict liability is present here because an exclusive right is a type of an absolute right that is directed against protection of that is protected against any third party. So any violation of a liability is a violation of an absolute right, so it's a delict liability. And obviously certain provisions, general ones, may be applicable, but we must be careful, and judges are cautious here, and the reason behind it is good, because at the plenary meetings of the higher courts, it is recommended to apply Article 401 and not an article on delict liability. So this is a general article pertaining to violations of obligations, so courts may be cautious because Article 401 envisages a higher entrepreneurial liability, unlike delict liability, where there is only liability with regard to the guilt. And this reference is quite obvious because businessmen quite often use such results, and violations by businessmen must be punished more strictly, because throughout the world the liability for violating exclusive rights is very high, and even there is no reference to guilt in many countries, be a private person or a businessman a violator. So that's why Article 401 is justly applied And since there were some amendments made because the wording was not clear when we have liability with guilt and without guilt, so now there is a clear definition which cases are encompassed by liability without fault and with fault, with reference to Article 401. So this is a practical proposal that was made by courts, is now embedded in Part 4. Once again, if we are talking about intellectual property, I'm like a hippie expert when answering this question. I think that we need to thoroughly reflect on this issue. This is delict liability. I have no doubt about it. Another thing that we need to be critical about referring to Article 401 and the fact that intellectual property rights protection, even when no guilt is found, then liability comes in. Well, Article 401 provides for meeting contractual obligations, not delict obligations that are governed by the presence or absence of the guilt. And in the delict liability, high standards are applied based on risks. Why is it happening? I'm not sure. Probably it requires understanding pertaining to the actual role of intellectual property in our economy, but in many countries actually liability pertaining to the violation of intellectual property rights is higher, and the damage awarded is higher than and the liability rate is higher than the criminal liability rate. Well, whether it is appropriate or not, probably it is a correct approach when we transit from an era when no intellectual property right holders were recognized, and now we are faced with a sort of scary stage. You know, some 15 years ago, I think we started seeing these videos about piracy and so on, and we only smiled at it. But now we all do understand that we need to respect intellectual property, but sometimes it is really exaggerated. So I would not say that this is in brick and concrete forever and it will remain intact. Actually, very often the structure is collapsing because obviously, though intellectual property rights violators, they are not businessmen, but they may not be, or they may be businessmen, but they are not aware of the of the beginning of the risk. As for this notion of the beginning of the risk, I have a lot of doubts about it. Another thing that will pop up in our practice, in fact, most of IPR violations are of delict character, whether it is civil law or criminal prosecution. Nevertheless, if the sphere of application of licensing agreement is expanding, and we'll see more of it when the economy develops, we'll come across an issue. What shall we do when a licensee goes outside the license? So obviously we are going to see what kind of norms we should apply, contractual terms or delict liability. So I think that everyone may express their points of view. I don't have a clear answer. As for the licensing agreement, the position is expressed in Part 4 to the effect that if a violation is connected to exceeding contractual terms, like the expiry of the term, the number of copies is larger, and the type of usage is a different one. So general norms of delict liability are applied. So you may find these issues in the resolutions of the plenary session, so thus they encompass all types of violations. It is an implicit argument for open licenses, because it turns out that actually this contract is not a contract at all, because if a person starts using a piece of work and it is an offer made by the right holder, we don't know whether the person really read the terms of the open license, or they do not care at all, and that's why they violate. So when they exceed the terms of the licensing agreement, we'll find out that the person is a violator, but he will be held liable under delict liability. So it's not clear why this contract is needed. Okay, abroad it is applicable, and it is not prohibited to resort to these provisions, because WikiLeaks or Wikipedia are created in accordance with the legislation of Florida or something else, and if on the condition of Creative Commons you place such licenses, then you act within the jurisdiction of the countries. But what if our citizens decide to use them? That is another thing. So that's why we have to include risky provisions in Part 4, because as soon as we invent a sort of type of an agreement, then we formulate, providing a sort of general wording, and then problems surface because our very creative users start using them in a very specific way. Though we define a specific case, broader interpretation is almost always provided. So we'll see. Probably these provisions will be included. We are having a discussion between two moderators. Well, I'm confused about the applicability of delict liability with regard to everyone. For example, if a product is used not in accordance with the established purpose. For example, if you have a lease agreement and you use property not in accordance with the terms of the contract, obviously no delict liability is applicable. Yeah, the practice is like this. Nevertheless, there is a shift, a bias in favor of delict liability, and at the same time there is also a reference to general obligations violations.
That's why I asked this question, because I hope that, well, there are clarifications. There may be changes to the clarifications coming from the higher courts, and this provision will somehow be clarified finally. My final question, it's not a question rather, but a comment. Don't you think that the provision on the open license is an institution coming from American and English law, and this is something alien to our law, and it will give more disadvantages than advantages. It will harm more than it will bring benefits. I don't consider open license to be a special license, just another way to enter into a license agreement, a simplified form. it is not it is not taken from Anglo-American law as such. From the legal standpoint, it boils down just in another way of signing a contract, not on paper, but by way of certain actions. So you click your mouse and you agree to the terms and conditions and you start using it, and that's it. I will probably follow up on what was said on the plenary. It is bad when economists write laws. They don't they do not know how to use the legal instruments. But it is equally bad when lawyers are trying to solve certain economic problems or to evaluate whether this or that approach from the economic standpoint is worthwhile. Lawyers, economists, professionals must work together, which doesn't work out in this country. Often, either lawyers invent some certain things, the economic content, or economists that are in charge of the content, but they also write laws regulating it. Whether it will harm or not, well, it is not the lawyer's responsibility to judge. Certain economic relations they develop, and they go, and the development of laws lags behind. If such economic relations develop on a large scale, you shouldn't try to ban them by legal means. This is not productive. This is counterproductive. This is a convenient institution, the open license, which was the Deputy Minister of Culture took part in our roundtable on the internet, and she said that modern day relations in the society in relation to the appearance of the net is such that many of us have become authors, and formally copyright laws apply to them. But if we ask those people, we would find out that maybe 90% of them do not claim to protect their property rights with those instruments that exist in the law, and they are not going to file any claims against those who will formally violate their rights and use their content, but formally they will be in breach of law. Our legal qualification is different from real-world relations. Therefore, I think it is necessary to strike a balance here. When people say that there are lots of pirates, we need to fight piracy, few people think that this is a manifestation of a disbalance. When violations are large-scale, something is wrong in the law. The law cannot ban something that is done by everyone. I'm not a nihilist with regard to copyright, but, well, of course, we need to somehow respond to it, and an open license with all those caveats that I made, that this is just another form of entering into contractual relations. But, you know, you won't commit mistakes if you only don't do anything. Good afternoon, Vitaly Kostalsky from the Skolkovo Foundation. I would like to thank Elena for her presentation. And this is not a question, this is rather a comment about stimulating the work of inventors. Little attention is paid to this topic in the legal literature. I'm talking about remuneration. this is not a legal term, but anyway, you understand. Remuneration for the creation of intellectual products, including patent rights. For more than 20 years, we've been observing a rather cautious approach on the part of the legislator, and this approach is such that the norms of the existing law on inventions in the USSR and on industrial prototypes or pilot products are applied today until the laws are adopted on the development of activities in the field of innovations and art. We should not avoid the topic of remuneration that goes to innovators. In the US, they adopted a law in 1980 which led to a launch of the so-called process of commercialization. It does contain certain provisions, and it allows professors of universities to receive a rather high remuneration. This topic is also relevant because, unfortunately, our case law and regulatory documents are extremely inconsistent in this area. I mean, both pieces of legislation and rulings by the high courts. So there is such a category of people that were accessory in the development of an innovation or an invention. The court rulings cannot be prohibit to give any remuneration to people who facilitated the creation of an innovation. So why should the legislator be so cautious? Are they simply not brave enough to abandon those, to cancel those provisions? There are lots of problems in practical life with heirs, with those people who terminated their contracts, work contracts with their employers. Well, I understand, yeah. Okay, I will respond to that one. I didn't quite understand one thing. You've put together several problems. You bundled them together somehow. Let us take them one by one. There is a law on inventions in the USSR which is still applicable in Russia. From the point of view of inventors, it is very beneficial because according to this law, very high remunerations are paid out. Microphone, please. No. Well, I understand. It is quite clear that it would be logical and correct to put an emphasis on agreements between the employer and the employee about what is created at the workplace, but still we have this law on inventions which rules out such a possibility. On the other hand, the civil code in the form that it currently exists in doesn't envisage any payment of remuneration to facilitators of any sort. And naturally, the laws clarify, with regard to Part 4, that this part of the law on inventions does not apply, and now probably the time has come to cancel old Soviet legislation on inventions and introduce new rules. Maybe a special law should be developed, but this is not to be included into the civil code. This is a separate issue. The civil code can just, regulate general issues related to remuneration. This is subject to the agreement between the parties. The employer must pay remuneration. It is stated who is responsible for that. It is stated there that remuneration exists even if the exclusive right passes over to the employer. Well, I don't know whether anyone will come out with such a legislative initiative. I received a package of proposals from Valentina Matvienko, and there is a proposal there to cancel this provision with regard to passing a new law. This is not for us to decide. We could only recommend that special legislation must be developed, but this is not, it should not be part of the civil code. The civil code may contain the text whereby such a law should be developed, but how it needs to be done, it is not up to the civil code. Since it is stated there that there must be some remuneration for something invented or created on the workplace, maybe some legal conditions must be prescribed in a greater detail. Since 2008 we have received lots of criticisms. It is not clear whether this right is inheritable or not. Yeah, and so we are proposing to write there that this right cannot be conceded or sold, but it is inheritable for the duration of its existence. It is also logical that heirs or employees that they should be receiving remuneration from the employer or whoever else for 70 years after the death of the author of some piece of work. Something is with the microphone. I can't hear the person speaking. I think that this is an issue of the contract between the parties. Myself, as a representative of the civil law, I always think that whenever possible it should be regulated by the contracts. It should be left to the parties to the contract to decide and how to regulate their relations, but there might be additional provisions if the government wants to provide certain incentives. Maybe they would like to support them through state contracts. I don't know what kind of level this act should be at. Maybe it should be a decree by the government or a law.
Questions, please? Natalia Matsinvan, senior lecturer of the state law. So I have questions about Article 1275. It states that copying scientific literature becomes possible without any restrictions, and it also talks about publicly accessible libraries. What is it about? What is a publicly accessible library? Will universities be classified as such? And also it talks about the absence of the purpose of generating profit. Well, you know, now we have copying machinery in libraries where readers themselves copy publications, and thus actually a university receives a rental payment from this copying machinery. Does it mean that a library generates a profit? This is one question. A second one. Why in item 3 there is a separate provision on copying dissertations? Will it give an impetus to the development of plagiat, because actually further on, when people read a lot of books, well, we can really see the plagiat. And actually, if we talk about a dissertation, then only the opponent, basically, and the author knows about it. So, as for libraries and as for dissertations, so we have two libraries that receive copies of dissertations. The public library named after Lenin and the public library here in St. Petersburg. No, an obligatory deposit is placed in a library of an institution where the defense of the dissertation takes place. Yes, that's right. But if we are talking about publicly accessible libraries, we have two of them. So we can't say that they are just manuscripts. They are shown visibly. So there are two copies that are publicly accessible. I'm not talking about university libraries because only students can get access to them. But here, anyone can come and look at them. So they are not manuscripts. So what is allowed? To make an electronic copy and store it in the same library and show it on a display. So there is no possibility to copy it. An electronic copy does not mean that you can copy this product and send this image by network. So you may use this copy in the easiest way. So in terms of plagiarism, it does not create a sort of difficult situation. As for anti-plagiarism system, then actually it provides a benefit because we can use a software to compare a specific publication, a specific document with it. So actually it's an instrument to combat plagiarism rather than creating a favorable environment for plagiarism, because public awareness with regard to a specific document of a scientific nature, is long forgotten. It's a sort of subordinate document that shows actually that this abstract of a dissertation is indicative of a potential for a person to receive a PhD degree. So any person may have access to anti-plagiarism software, and anyone can check actually whether a specific publication is an independent product. Well, a publicly accessible library is a library to which anyone can come. Well, probably you must become a subscriber, sign an application, but it cannot be closed for specific groups of people. It is open to everyone. What else did you ask? About copying machines, right. As for this case, it's quite a problem. because it is written without the purpose of generating profits. Generating profits implies that costs can be reimbursed, because actually a profit is something that creates a sort of bonus. And actually, right holders insist on replacing this wording with the wording without obtaining a profit, which is, in our case, is not possible. Technically, it will require the replacement of a huge number of provisions. There is also some other options without a commercial gain, something like that. But we may argue that obviously this is one of the articles that will be changed by the State Duma. I'm not going to insist, and probably in a specific situation a court will not make the following judgment. But to my mind, this situation does not imply generating profits. It is a sort of necessary costs. Well, I do agree with Elena. As for information access rights, I'm not frightened by the publication of dissertation. To my mind, it is not even enough. We think that yearly papers and diploma publications should be published too, because actually it is really an anti-plagiarism instrument, and it is an instrument to broaden access to knowledge and information. It is one of the advantages of internet, and our society may be developing at a rapid pace because the level of education and knowledge defines the future of a person. Of course, you may be a genius from the very birthday, but actually more people are capable of developing when they have access to information, and the library in this case is a warehouse of knowledge. So dissertations, and I think we will have more publications. In the USA, there are even more of such cases than we have now. So people will proceed because knowledge is not only found in books, dissertations, but video materials and musical materials. Of course, it is difficult to differentiate between entertainment and knowledge-generating materials. But if we resort to patent law, I think the level of knowledge accumulated by humanity must be accessible for non-commercial use. Probably my parallel with the patent law is not so appropriate, but at the same time, you know, when you obtain a patent right, you receive access to information about parts and components. So commercial use concept is very important, but to be saturated with knowledge and ideas not for commercial use, obviously such a product must be accessible. Of course, we have different opinions from internet users and right holders, but actually I must say that we, in the end of the day, will be able to strike a balance. If we are going to talk about the fact that electronic copies can be used only inside libraries, like Article 1275 states, no dissemination of information will take place, because you will have to go to Moscow, to the Lenin Library. So far. I'm for uploading it for public, as a public domain, because I think it will increase the level of dissertations, because now we have an electronic library of dissertations, but you have to pay quite a lot of money to gain access to it, and the library has been using this tool disregarding any law. This is not right. As for uploading dissertations in the internet, you shouldn't forget that this is a product of scientific work that can be published as a separate book. It is good when we are talking about cultural studies, but what if it is about technologies? Sometimes information there is classified and they contain patent enabling information. So that's why these dissertations may not be uploaded. We should create an electronic copy. E-carriers allow us to accumulate and streamline information. If this huge layer of knowledge that is currently stored on paper in libraries and deteriorate because books become very books are not in a great shape. So to upload all dissertations currently wouldn't be possible right now, because these are monographic research geared at increasing scientific status of a certain person, but at the same time they might have a capacity of generating profits. So Igor was talking about specific situation and trends, but we are faced with these pending issues. So you see, on each specific issue, we come across a set of diverse interests. Well, copyright is actually a very subtle balance of interests, ranging from the desire to provide access to everything and large companies who want to charge you for everything. Well, actually, these companies do have a lot of employees, and we can't actually keep up. We can't be satisfied with the situation when a lot of jobs are lost. We are all authors, as Igor said. It is good when you are an author and you are a blogger, you have a salary, and in the evening you just write something that will be read by 5,000 people. Well, it's okay. But what about a professional author who all their life has earned money writing literature, but they are of no interest because they do not write in blogs. They want to publish books. And the problem of professional creativity is brought about. Okay, we may bring up our own authors who will write books, but how are we going to make films and to compose symphonic music? These are quite complex issues. That's exactly why intellectual property rights law exists, so that we protect interests of creative persons. They are non-tangible rights, they are property rights, and provide for their material well-being. When I was talking about internet access, that doesn't mean that everyone will upload and everyone will have access. What I meant that remote access, and given that there is a certain licensing agreement is signed, is provided for to people. This is the way for our legislation to develop both at the national and international level. I can't but react to the reference of old type authors who will no food to eat and no nothing to drink. Well, the thing is that technologies are developing at a rapid pace. What was impossible in the past is possible right now, but not everyone wants to adapt to the changing environment. Not everyone is interested in blogging. Not everyone is interested in internet surfing. So some people are used to the way of work they have used all their life, and we should not abandon their interests. More, maybe after 20 or 30 years, we won't be faced with such issues because the world will be operating in a different way, but maybe other ways will be identified. They are identified even now when money can be earned. Well, it's not a topic for our today's discussion. However, not only bloggers that are happy if their blogs are read by 10, 20 or 10,000 people, and some people even earn money through it. But serious companies, they have abandoned combating piracy in their regular understanding, but they earn money through the traffic. Not everyone is ready for it. Since it's a transition period, not always a profit is generated. Not only talking about music, videos, well, we do have e-books now. However, the sector is lagging behind. But after 30, 50 years or maybe earlier, we will end up with something. And then there will be a high level of consensus between the stakeholders.
I have several comments to make. My name is Elena Machilova. I'm from the Mariinsky Theatre, a lawyer. Practical questions. Number one, electronic means of information storage are quite young. It is too early to say how long they will survive, while paper carriers such as the Bible and everything else, they've been in existence for 1,000 years, and they're in fine shape. Only time will tell who will win in this rate. I know that the State Film Archive, although video materials are digitized on a large scale, they think that restorers and custodians, they say that magnetic tape is a better way to preserve information, not a backup storage facility. Maybe they will convert back digitized content from digital carriers onto magnetic tapes again, because they know how to store tapes properly, and they don't know properly how to deal with digital carriers of information. About general access to libraries, it is a very topical question for us as well, because we have huge music score archives, Imperial Music Archive. When we are not a public library, we are a library of the theatre. We store a huge amount of information, manuscripts we have that have never been performed, and the expert community are extremely interested in this, but we keep them away and we let them into our archives on a very selective basis, because we are a theatre. We are constantly working body which might take advantage of its historical benefits, something that has been stored for our predecessors. We need to use that as a competitive advantage today and tomorrow. We are working on it, not too fast probably, but in a consistent manner. During Perestroika, there was a total onslaught on us. There was one large organization, an American organization. They wanted to copy all our scores on microfilms. There was a very strong battle fought then, but we prevailed, and we use our materials the way we want and to the extent we want, taking into account the demands of the music market today. So general access to archives is a very serious problem. About 2 years ago there was a very profound discussion at the Presidential Library, and various scanning equipment manufacturers sponsored that conference. So the idea was to totally scan the entire museum fund, the inventory. On the first day everything were in favor, but then people started to ask why should we do that, why should it be done on such a large scale. It is quite clear why those scanning companies want that, but do museums need it at all? Do we need this general access? We still need to find some sort of a balance of interest here. One other comment that doesn't relate to libraries as such, about the state orders whereby the government orders films or other works of art, or say theatrical performances. An idea was expressed here that since it is ordered by the government, it should go into the public domain. In practical terms, it means that the government should have to pay a significant sum of money so that high-class professionals agree to do it. They would agree to work for the money. They must receive some incentive to work for the government. I do agree with the colleague from Skolkovo in that respect. The same applies to the video recordings of our performances. We do not pay any advance payments to our performers and directors. We tell them we will probably earn something from the work, and then we will share with you. So we should not talk here about public domain. This is the quality of what we are doing will suffer significantly. I mean, well, do we have normal government orders in the field of culture? No, that's the first question. Yeah, even if this model will come into being, this won't eradicate the practice of extending grants or subsidies. If you receive this money in the form of subsidies, and the organization that creates something will retain the copyright to whatever will be created, these models may exist in parallel. I would like to say that, well, what refers to the government order or government purchasing, it's just a proposal for the future. There is nothing of the kind in the draft code. I know that there is a proposal that has been submitted to the State Duma, and those proposals are of an opposite nature. So the idea is to give the right to the one who did the work if it is not effectively disposed of by the right holder. About the music scores, I know the situation in the field. I know that many foreign companies do not spare any effort to get access to music scores. Today it is not allowed to photocopy music scores, even for private purposes, individual purposes. You are not a general access archive or library, and you can decide how you are going to deal with those music scores? Are you going to keep them, to use them later on in your theater, or do something else with them? This is a unique object, and it makes sense that the right owner, the right holder, keeps the music score to themselves, whether, yeah, and it is up to you to decide in what form to keep these music scores, on the paper or in some other format. It is your decision. Vladislav Bulatov. I would like to add my opinion in what refers to the disposal of an electronic copy that is going to be stored in the network or on a single computer in a library or elsewhere. I mean, inside the library. If you communicate with the Lenin Library, there is access from the outside. There is search engine Sigla, which unites all libraries of the world, but I'm not talking about that now. Seeing the disks that contain the passport data for each and every one of us, including our license numbers, passport numbers, addresses, everything is disseminated absolutely openly, in spite of the requirements that exclude such possibility, because those data are confidential. Music scores or other books, in order for them to be intact, we need to somehow ensure that employees of libraries and other institutions should not divulge this information to other parties. They must be held liable, including criminal liability, if this information is disseminated to any third parties. Because those companies that are willing, they will find a person working inside that organization who will be able, and they will be able to obtain whatever information they need. And we need to take that into account, and we need to codify that. I have a brief question. I'm Deputy Dean of the Faculty of Law, Svetlana Mirolyubova, Deputy Dean of the Law Faculty of St. Petersburg University of Economics and Finance. Both in the current civil code and the draft law, there are provisions excluding some biotechnological invention from the domain of patent rights, those inventions that are against certain ethical norms. I mean, cloning of embryos. There is another law that it is up to 8 weeks, and what happens next, whether it is an embryo or not, we don't know. Whether it is an invention or not. The civil code speaks about industrial and other uses. Other uses are undefined, and there is an instruction from Rost Patent where it states that there is no legislative definition of moral and ethical values, and if a positive decision is taken on issuing a patent, we should also try to foresee the reaction on the part of the general public, how the general public should react to a patent if it is issued. Will there be any legislated criteria, or it will remain at the level of Rost Patent and similar wordings? Again, we come across the same problem. Shall we explain everything to the last point or not. Similar restrictions were introduced by international agreements. Intellectual field is a field where international agreements are enforced, and we cannot ignore those instruments if we have signed or are planning to sign appropriate international agreements in the future. This is because of those instruments. But as far as the instruction by Rospatent goes, well, they do not always create outstanding documents, that's correct, but it is just a piece of secondary legislation. But in a situation of a conflict, people will go to the court, and the court will decide what kind of criteria apply in this or that case, and the court will be guided by the judge's perceptions. They may also invite experts. But I think the court will be able to resolve this problem. As far as trademarks, there are very funny rulings. One trademark was not registered because it was on the verge of obscenity. So people are guided by their understanding and perceptions. Maria Bogadukhova, a lawyer from an NGO in St. Petersburg. I have a question about trademarks. So there is a company that uses a certain trademark for its own purposes to identify products, and there is another company another company provided the service with this trademark. And then how can we streamline the relations between the holder of the right to the trademark and the provider of the service under this trademark? So we don't know how to operate in those conditions. Have I made myself clear? Maybe I missed something, I'm sorry, because everything is so, convoluted. The idea is probably that before, the civil code didn't envision the publication of the application until a decision has been taken. Now Rospatent does so, and this is a good measure. This relates to inventions, utility models, and industrial prototypes. The application is filed, it becomes known to any person, and if necessary, the procedure of objections should be started. If some third party has used the trademark, and then a claim is filed against him, well, this is a widespread situation in our case law. In principle, this person can prove the right if he can prove that he had started using this trademark prior to the registration of this trademark by another entity. And I always recommend people, if they want to start a serious business, to register their names, trademarks, whatever. This is the best approach. Brand names as a means of individualization, but any printed mass media, the first thing they do, they go and register their title. Well, the time frames are very long. It takes a long time. Many years ago, I registered trademarks. Everything is, well, it's a routine procedure, not a lengthy one if you do it cleverly.
A couple of more questions. Maybe I'm asking too many questions. We have the notion of a share in an exclusive right. Previously, we didn't have anything like that. So we are concerned about the turnover of this share. It is obvious that it is limited, but it is not only inheritance. And if the number of heirs, especially in the sphere of copyrights, is more or less clear, then with these shares turnover, it is really difficult to define the number of right holders if we are going to use this notion. Maybe this notion is too premature. Well, we had to do it because you think that this this issue is not topical, but actually norms of the title of shared ownership was applied. Well, imagine there are two heirs of a composer, one in Moscow, the other in Paris. And when they inherit certain assets, they agree that they are going to sign licensing agreements. So one issues a license in Paris and the other one in Moscow. And then it turns out that the exclusive right has been issued by two heirs for the same territory. So it is written that they should split it 50-50. But just imagine, you have one car and one heir is in Moscow, the other one in Paris, and they are somehow putting apart this car. So we may give a parallel of undivisible thing, but property rights are not applicable here. So that's why we had to develop a set of rules that are really opposed, because they are not similar to usual ones. But in reality, we do come across situations with several heirs, and one of the heirs says that I want to abandon all my rights, including my share of the copyright, like mother and three sisters. And mother would say that I'm too old, I want my daughters to inherit. So we don't have an instrument under which this mother could leave the community of the right holders. Now we may ensure it, and we have a 50% increase in the shares of the daughters. There is another case. There are several co-authors. One of them leaves this country and wants to hand over his share, maybe free of charge, maybe for money, to the other co-authors. We are stating that the share cannot be handed over to a third party, because otherwise the situation referred to you may pop up, and the other co-authors can be impeded by this third party who may take advantage of the situation. So we are trying to protect authors. If we say that these co-right holders are legal entities, then no question arises. Even if they are not legal entities, but they are heirs, they may alienate their share to a third party if the others do not object to it, through obtaining agreement from all the other right holders. So the right will be assigned to a third party. It's not exactly shares, but these are, so to say, conventional shares, conditioned shares, so that a person can leave the community of right holders. But it seems to me that this instrument is not well developed, because if there is a preference in handing over a share, that must be met with regard to an exclusive right. There is no such a mechanism. There is a procedure envisaging warning it is written about agreement, but what if there is no agreement? Are these transactions void? So, okay, if a user received um, received permission from 25th right holder of a share, and he can't check the agreements. Well, why are you talking about a chain? If you are a core right holder, you are a core right holder, and you need to obtain permission from all the others in any case. But you are actually, there is no analogy to property rights here. In Article 3, Section 7, we are stating that we are defending only the interests of the right holder and nobody else. Abuse of rights. Abroad, copyright trolling and patent trolling are widespread, so they procure general patents so that further on they really impede the activities of companies that really manufacture things, so that they identify products patented by them or parts patented by them, and companies earn by identifying violators, and they demand from them money much more than they could earn through the content. I looked at the draft, and Article 10 is amended, thus reducing the scope of authority under which courts may award judgments with regard to the abuse of rights. On the 17th of April, one of the district courts awarded a judgment that the right of a trademark was violated when in an article the image of this trademark was published. It's a famous case of Vorodak versus Verbitsky. So what can be used? What can be done? I think that Article 10 must be applicable to intellectual property rights, but carefully. Even abroad, where anti-monopoly regulation is applied and issues of abuse of rights surface, nevertheless, in practice, a case ends up in a court quite rarely. In Russia, such cases are not widespread with regard to trademarks. Well, I cannot remember any case of patent law or copyright law. Well, we need to have this instrument as a sort of reserve, but how to apply it, it's not clear. It seems to me that it is expedient to reproduce a provision similar to Article 10 in Part 4, thus sending a message to the community that such norms are applicable. But bearing in mind the fact that our courts are very cautious, we shouldn't be concerned. Even if such a provision is included in Part 4, it is unlikely to be widespread. And besides, the practice of court indicates that such that courts protect trolling actively. Well, actually, our time is over. Thank you for your attention. All the best.